Well, good morning and thank you for joining us. If you're still here with us, I apologize for the delay. We've had some technical difficulties this morning, but we're back live now, and I want to welcome you to our online town hall. My name is Michael Gault, and I'm an eminent domain attorney with Bell Carrington Price and Gregg. We're based in South Carolina, but we are a regional firm representing landowners in eminent domain cases like this one throughout the Southeast. Now, if you're here with us today, you're obviously here with us about the Jasper Okatie Riverport transmission line project. If you've probably, because this project has been going on for quite some time, you probably already know something about this project. In fact, you may have already been contacted by Dominion or one of their representatives regarding what we would call right-of-way acquisition in this case. Let's start just briefly by talking about the project overview. Obviously, we're going to have two new 230 kilovolt lines and a new substation. These two lines will run from, one will start at the current Jasper generating plant, and one will start at the Okatie substation, and they will conclude at the new Riverport substation. But in order to construct these lines, as you may can imagine, Dominion Energy will need to acquire new property, new right-of-way through existing landowners' property through the theory of eminent domain. What is eminent domain and what does that look like? Well, eminent domain, generally speaking, is a legal theory that says that the government or a quasi-governmental entity, in this case Dominion Energy, can acquire private property for a public purpose. Sometimes that happens whether the landowner likes it or not, as long as certain criteria are met. But it's important to know as a landowner that even though Dominion Energy probably has the legal right to obtain some of your property for a project such as this, the most important right that you have as a landowner is the right to what we call just compensation. That means that even though Dominion Energy can obtain this property, they have to compensate the landowners fairly and adequately for the property that they obtain. Now, that's not always as simple as having an appraiser for Dominion Energy come in and tell you how much they think that your dirt's worth. Oftentimes, there are damages associated with these takings. And so those damages may be in correlation to a residence or a structure that's on the property. In some situations, those damages may be in relation to an existing commercial enterprise or a business that's on the property. The damages can be complicated, but that's sort of where we come in. At Bell Carrington, we have experience in eminent domain matters. We know the process, we know the language, we oftentimes know the players and the people that will be on the ground for Dominion or for the condemnor. In this case, it is Dominion. And we can help guide our clients through that process and help make sure that their rights are protected. Again, among those most important, the right to just compensation. So it's important for us to be able to look at each individual case specifically to find out how each individual landowner is impacted and to be able to advise our potential clients and then our future clients as to how this new acquisition will impact their specific property. Obviously, I'm not in a position in a public forum like this today to give anything more than general information, but at Bell Carrington, we have some proprietary software that will allow me to pull up each individual parcel and the impact to that parcel during our initial consultation. That consultation is always free at Bell Carrington, no charge, no obligation. We're happy to speak with you. We have a team, and you'll see our contact information over in the chat box now. You can call or email me to set up that initial consultation. And once we're on the phone together, I have the ability through that software to pull up your property and to see highlighted in red the actual impact to your property. We can talk about the impact to the dirt value. We can also probably start the discussion of damages to the remainder of the property to make sure that you see the full picture and that your rights are fully protected throughout this process. Now, what does the process look like? Dominion at this point has started acquisition. From some of you, they may have concluded acquisition. They may have made a settlement with you already. But if not, then the process begins with negotiation with Dominion. If those negotiations are unsuccessful, then eventually what's known as condemnation will be filed. A condemnation is basically the legal principle that allows a governmental entity or a quasi-governmental entity like Dominion to file something with the court, basically sort of like a lawsuit, saying we are proceeding with eminent domain in this case. We are going to try to take this property, and then we can, argue about the value through the court system. Many cases don't make it that far. Many cases are settled prior to condemnation. But if condemnation is filed, then there are a number of steps that would take place throughout that proceeding. Those would be mediation. Those might be depositions of witnesses in the case. But at the conclusion, if the case is still unsettled throughout the condemnation process, then ultimately, as a landowner, you have a right to challenge the just compensation to the taking of your property through a jury trial. You have a right to seat 12 jurors of your peers in a jury box and to try the case and have that jury tell you what your taking is worth. Now, as with anything, I think those of us in South Carolina have seen recently that jury is never predictable. And in that case, that's true in criminal cases, it's true in injury cases, and it's certainly true in eminent domain cases. And so, oftentimes there are cases that should be tried, but the vast majority of them are not. They're settled either pre-condemnation and certainly before going to a jury trial. So just to recap, these lines are coming. The routes are finalized. You may have already heard from a right-of-way agent or someone that Dominion hires at the outset to try to negotiate these right-of-way takings. You do not have to take their first offer. You certainly don't have to go through this on your own. We are here so that we can help advise landowners in projects like this throughout the eminent domain process, to give you some real world advice, some real world experience, and to make sure that your rights are protected. So again, this public forum, I can't provide legal advice. This is not intended to. This is just intended to provide some general overviews of this project and the eminent domain process in general. But my contact information is in the chat box. I invite you to call or email me at your convenience, and I'll be glad to hop on the phone or on a Teams meeting with you, or just to correspond via email to find out if you're impacted, and if so, how Bell Carrington may be able to help. Quickly, let me address attorney's fees in eminent domain cases. Oftentimes, folks are hesitant to hire a lawyer in a case like this because traditionally attorney's fees are expensive. At Bell Carrington, in our eminent domain department, we don't require upfront or out-of-pocket attorney's fees. There's no retainer due at any time. We operate on what's known as a contingency fee, which is ultimately a percentage of the recovery, a percentage of the just compensation that we're able to recover for each of our clients. Again, I can't discuss those individually on YouTube Live, but I'm happy to talk with each of you individually about what that fee structure looks like and how that may play out in your particular case. But it is important to know that you don't have to come out of pocket for any attorney's fees. There's no upfront retainer or upfront cost at all from any potential client. So feel free to reach out to me. You see my contact information. I'll answer the phone directly, or you can email us and I'll get back to you. I want to thank you all for joining us this morning, and I apologize for the delay. This is the first time we've had technical difficulties with our virtual town halls, and hopefully the last. But I want to thank you for joining us. This will be posted, so if you missed the first part of it, you can go back and catch a recap here in the next few minutes. Thank you again, and I appreciate you joining us. Look forward to working with you.